We will go on the record in the matters 25 TR 775, 25 TR 1015, State of Wisconsin versus Mark Chanel, State County of Burnett versus Mark Chanel. The county appears through Assistant District Attorney Jose Vila in person. We have Mr. Chanel in person.
Right out of the gate, this case looks like a routine traffic matter, but don't let that fool you. What we're about to see is a courtroom chess match where legal technicalities, timing, and strategy could completely reshape the outcome. A defendant pushing a Miranda argument, a judge who's clearly seen this play before, and a trial that's quickly moving from possibility to inevitability. The real tension, whether this case collapses under weak legal footing or explodes into a full-blown jury battle. Stay sharp because every word here matters, and one misstep could cost everything.
We're here today for a status conference. Mr. Chanel, there was a little glitch and whatnot, whatever. So I believe we're going to count, if you already have not done it, your jury demand for both is accepted. So we're going to be able to have a jury trial. It'll be a dual jury trial, same day, same time, same place, just a little bit different. I have received and reviewed your renewed motion to suppress the information that you requested, which is different to some degree, but for the most part, it is not. It's not very different. Other than that, well, I'm going to turn to Mr. Vila. Have you had an opportunity to discuss this with Mr. Chanel?
I have not, Your Honor. My understanding is we did have a meeting set up at one point. My notes say that he was supposed to call into the office, but I never got a call. But if he still wants to sit and chat, we can have one last.
We're going to sit and chat right now.
That's fine.
That's what you're going to do.
So
I'm going to tell you, I don't know if I'm going to guess you read his motion.
It's largely the same stuff we dealt with.
It is. And so, I mean, I've already ruled on everything except, I'm going to be honest right here in paragraph 5 that you have Miranda violation and invalid consent to vehicle search. What are you asking me to suppress? What statement? Because you didn't make any statement.
That was the main thing. There's no Miranda rights.
And whether they violated your Miranda rights or not, if they violated your Miranda rights, the court, that's where you ask the court, please suppress any statements I made. I did it, man. I did it. That's what you would ask me to suppress. But I'm not hearing that or reading that there's any statement that you made that you want me to suppress. So
the point was about the police report was different than the actual video. It was totally
about
different.
Giving you Miranda?
Yeah, no, but Miranda rights there's no Miranda rights said. And
again, that doesn't matter because you said nothing that you want me to suppress.
Okay. The police report and the body cam was different in that scenario.
In the timeline, right?
No, in the police report stated that I requested my vehicle be moved, but the body cam footage shows that the officer stated that he asked me in the body cam footage.
So you're upset that the officer moved your vehicle off to the side of the road?
There's a discrepancy in the body cam video footage and the actual written report.
So
it's different.
Again, that Miranda doesn't come into play with that.
Okay.
Miranda only comes into play with statements that you made.
Yeah, okay.
And I'm not seeing that you made a statement that you want the court to suppress. So here, this is essentially, except for that little bit, exactly what the court ruled on before. So I'm going to deny the ability to have a hearing because there's not sufficient evidence for me to even see that there's anything that we need to flush out in a hearing. In a trial, you have the ability to do all of those things, and that's where the credibility of the jury gets to come, and they get to hear all the facts, and they get to be the determining body of the facts and the credibility of the witnesses, things, okay? Right. But here's where I'm going to give you time to discuss all of this and your case and all of the things right now with Mr. Vila, because it sounds like you didn't have the chance to have your meeting. So go out and chit chat and talk, and then we'll come back and we'll go on the record a little bit and we'll see if there's anything to do. But this is your time to try and negotiate, to work with the state and go from there, okay?
All right.
All right. Thank you. Then we are briefly adjourned. Back on the record, same appearances as previously noted. The parties have had an opportunity to try and discuss the matter. And I've been informed that there is no agreement and that we're going to proceed to trial. Do we have a lab analyst at least at this time so we can schedule it?
Yes, Your Honor, just let me pull up the system. It's a
You
little
do all
slow.
your thing and let me know, and we're just going to schedule it right now. But
Fair
here's
enough.
the deal. While he's pulling all that stuff up, I'm going to go over some things with you. You do have the right to an attorney. This is an attorney that you would have to hire and retain on your own. This is not one that is the ability to get court appointed or a public defender, because this is a ticket. All right. It's an OWI first ticket. So that is one in which if you wish to have an attorney, you would need to hire and retain your own. Okay. Or you can represent yourself. All right. And so do you know if you are going to retain an attorney or are you going to be representing yourself?
I'm considering an attorney. I'm looking right now.
Okay.
So I'm just looking around right now, seeing money wise.
You talk to all of the attorneys. What I'm gonna do is right now I'm gonna set the trial date. The problem with proceeding and going down this like this without having an attorney right now is it's gonna be harder to retain an attorney if they know there's a trial date. So I'm gonna give you a little bit of time. Usually we go boom, 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 and we get these done rather quickly, or as quickly and efficiently as we can. But it's going to all depend on the lab analyst, because we're going to get a lab analyst and they need to be a number one. Okay. And they're coming from Madison or Wausau, one of those two. And so we need to make sure they're the people that handle these cases for the entire state of Wisconsin. So we're going to make sure that we get a date where they're number one, so that we know that the matter is going to go. Mr. Vila, do you have that information?
Yes, Your Honor. The lab analyst, so this is the State Lab of Hygiene, and it's Sarah Nicholas.
Sarah Nicholas?
Correct.
And do you have a number?
Yeah, the FX number is 25FX015701.
Oh, great. Off the record for a second.
Toxicology, this is Susan.
Hi, this is Judge Mogen from Burnett County. I am calling to schedule a trial for an OWI first with Sarah Nicholas.
All right. And what is the date?
Well, let's just try and, oops, sorry. Sorry, I got off my calendar. Let's get a date. June 3rd.
Okay, that is her day that she has to stay in the lab. So could she do this trial by phone or Zoom?
That is a possibility. So we could schedule it for that date and time. We would then the state would have to file a motion to do that, and we would have a hearing. That's fine. So at this time, we can schedule her for June 3rd.
All right. And what is your FX number, please?
FX number is 25FX0150 or 015701. So FX 015701. 2025.
15701. All
Yes.
right. And is this a court trial or a jury trial?
Jury. 6-person.
And the subject's name, please.
Mark Chanel, Chenal.
A contact name and phone number.
Should I do Mr. Schmidt or you?
It doesn't matter, Your Honor. You could do mine with the office phone number.
Jose Villar, but it's Villard, Villard. Telephone number 715-349-2167.
All right, I do have you all set then as a number 1 with Sarah by phone or Zoom on June 3rd.
Excellent. Thank you so much.
You're welcome. Bye.
Bye. Back on the record, same appearances as previously noted. We have scheduled a number 1 jury trial for June 3rd with Sarah Nicholas, who is the lab analyst. We have the number 1 scheduled. However, then that is her availability would only be by Zoom or telephone. And so, Mr. Chanel.
This is a critical legal reality check, and honestly, it catches a lot of people off guard. The defendant is raising a Miranda violation, which sounds powerful, right? But here's the catch. Miranda rights only matter if there are actual statements to suppress. No statements, no suppression, simple as that. The judge is essentially saying, even if your rights were violated, what exactly are you asking me to throw out? And when there's no clear answer, the argument loses its foundation instantly. This is where courtroom strategy separates from assumption. You can't just cite a constitutional right, you have to connect it directly to evidence. So let me ask you, do you think the defendant misunderstood the law here, or was this a last-ditch attempt to create doubt?
If the state would like to proceed on that date and time, they have to file a motion with the court requesting that I allow them to have that lab analyst appear either by telephone or Zoom. And you'll be able to argue either for or against it. You can either say, you know what, I don't care, because if she's by Zoom, she'll be on that monitor over there, and she'll be over there on that monitor right there. So you would be able to see her and watch her and question her, and so will the jury. They'll be able to watch and see both. So you can either say, that doesn't bother me, that's fine. Or you can say, you can argue to the court, no, I want her to be here in person. I want her to come up from Madison, so then she can be seated right here in the witness stand. But you would have the ability to do that. So they would need to file a motion. I would set a hearing date to have that, in which I would am probably going to do that anyway, because we're going to probably need, well, we will need to have a final pretrial. We can either do it on the final pretrial date or before, but anyway, that's where we are, and that's where we're going with that. So if you are able to or want to hire an attorney, retain an attorney, then you would need to talk to that attorney and let them know about the trial date and the final pretrial. Otherwise, you are free. It is your constitutional right, your right to represent yourself. The only thing is if you are representing yourself, the court must ask you certain questions and do some a colloquy on the record with you, just to make sure that you are that you understand what's going on. Right, exactly. So see, you understand.
Is that the earliest June?
That is the earliest I could do.
Possible.
Yes. Yep.
I
mean, you're lucky I was able to get that date and time, because otherwise we would have to push it out a little bit generally for my calendar. But I'm going to tell you, I double booked you with another trial, but I knew that you wanted to get this resolved as quickly as you can. So quite honestly, you're going to be my number 1. That other trial with State v. Melissa Maloney will be my number 2. Okay.
Wait, one other question. I filed an appeal for my driver's license, and they never gave me a court date or any kind of, they're supposed to call.
Who did you file an appeal with?
The DMV.
Then that's completely with the DMV, and that's an administrative type of thing that doesn't happen here with the courts.
Oh, but if your rights before trial are denied like that,
then you have to formally demand that with the court as well. We're 2 separate entities.
Yep.
And so they have their own thing. The court has its own thing.
All right, thank you.
But after you get a ticket with the court, it has to be within 10 days after the ticket.
Yeah, it wasn't the timeline, and I have certified too. So.
Oh, I don't have it though. You didn't file it with the court.
The appeal for the DMV.
Correct. I don't have that. And you don't file your appeal with the DMV is again different than what you would demand with this court.
Right.
So, but that only comes into play, this was not a refusal, correct? Because they did the
No.
informed consent.
It was a refusal. It was a blood search warrant.
Okay, all right. So yeah, it would be a totally different thing. So are we even worrying about a refusal then? Are you asking to have a refusal hearing?
I'm not setting a refusal hearing for this one. We're just going for the OWI.
Okay, then that's fine.
But if DMV is doing their own thing, they're doing their own thing.
So quite honestly, in terms of the legal world, the state's not seeking a refusal, so that's legally better for you here in this legal world. As far as the DMV, that's your own. It's its own animal. All right, they have their own process within their department.
Right.
All right.
Thank you.
So now let's get a final pretrial, June 3rd. I think I'm just going to schedule a final should we have a motion before? No, final pretrial / motion hearing to be heard with the lab analyst, because either if the court says, you know what, no, I want her to be here in person, then we're just going to have to reset that trial date to a later date and time. But if you say, you know what, Judge, I'm fine with that. I'm fine with her by Zoom. Then that June 3rd, we don't even have to have a motion. We don't even have to have argument with that if you agree to that. And then I wouldn't need to reset the trial date, Mr. Vila.
And just to flag this in general, if he is interested in pursuing counsel, I'd imagine we'd have to check with that attorney's calendar too. So this might need to get pushed regardless. That's all I want to flag.
If the court allows it, because it's up to the court. And Mr. Chanel wants this matter to proceed in a timely fashion. From day one, he has said that, correct, Mr. Chanel?
Yes.
You want it resolved as quickly as you can. I'm trying to accommodate with that. How about May 6th at 2:30? So that'll be a final pretrial, and I'll say final pretrial motion hearing. But if we don't need to have that motion hearing, then both of you will let me know. Because I don't want to put you on the spot right now, Mr. Chanel. I want you to be able to think about whether or not you want the lab analyst here in person, or if you're okay with her by video. It would be video conferencing. I wouldn't allow telephone. I want to be able to see her. I want you to be able to see her. I want the jury to be able to see her. But you think about that, and you can at least talk to the state about that. If you don't object, then we can remove the motion hearing. Otherwise, we'll proceed and we'll see if the matter is resolving or if we will go to trial. Okay? Anything else?
And I assume we'll have a scheduling order as well.
Mary will get one out in the next day or two.
Perfect. Thank you.
For the missing police, the body cam footage of the time you got pulled over to the time I was at the hospital.
What you would need to do is you need to do a formal demand to the state.
Discovery.
Yes.
Then I have to do it, and then you'll have to demand that.
Well, if they're not complying or they're not giving you the information, or you think that there's more to give, but if you did a formal demand and they gave you discovery information,
besides that one,
and if you don't think that they gave you all that you're entitled to, then you would have to do another formal demand, being very specific as to what you're asking for. And if at that time they would need to respond, either we have it or we don't have it, and then you would need to file a motion with the court with whatever you're asking. Okay?
Yep.
Anything?
And just like that, the tone of this case is locked in. The motion to suppress is denied, not because the judge dismissed the argument emotionally, but because it lacked legal substance. From there, the courtroom shifts gears into strategy mode. Negotiation opportunity offered rejected, and now the path leads straight to trial. What makes this especially interesting is how the judge balances control with fairness, denying weak motions, but still giving the defendant space to resolve the case. Add in the complexity of self-representation, the scheduling of a key lab analyst, and even the question of remote testimony, and suddenly, this simple case becomes layered with risk. At its core, this case highlights a powerful truth. In court, precision beats passion every time. If you can't clearly tie your argument to evidence, the system moves forward without you. So now it's your turn. Was the judge too strict or exactly right? And should the defendant go to trial alone or bring in legal backup before it's too late? If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.